You are claiming interest.
My lord.
Claiming interest.
My lord.
Where is the prayer in the writ petition?
My lord. Relief number 2.
Are you on ad hoc basis?
No.
Then as on September 2012, what is the material to show that you are a regular holder of the post?
My lord, initial appointment of the appellant was in the year 1996.
You are maintaining with some other money.
No.
Then without salary, how did you survive for 5 years?
My lords, may I plead your lordships? This case, lords, the appellant had preferred the filing of this memo of appeal being aggrieved by non-consideration of his claim in relation to payment of interest for the period the salary of the appellant was withheld, the first thing. And the second thing is in relation to non-confirmation of the interim order passed in relation to the vacation of my quarter duly allotted to me in the year 2010 itself. The relief prayed for by the appellant has been quoted in the memo of appeal as well, my lords, at page number 2.
You are claiming interest.
My lord.
Claiming interest.
My lord.
Where is the prayer in the writ petition?
My lord. Relief number 2.
Relief number 2 what?
Of the paragraph number 1, Roman 2.
Huh?
Paragraph number 1, Roman 2.
During which period you have not been paid salary?
My lords, my salary was withheld since the month of September 2012.
September 2012.
And even
Up to what date it was not given?
up to the date of the filing of this writ petition, and even after the order has been passed in favor of the petitioner in the connected writ petition,
What is the reason?
salary.
What is the reason for non-payment?
Now they are saying that the services of the petitioner have not been confirmed, which is far from truth. My services have been confirmed. The learned single judge has held that no, that was not required.
No,
Petitioner,
are you on ad hoc basis?
no.
Then as on September 2012, what is the material to show that you are a regular holder of the post?
I mean, initial appointment of the appellant was in the year 1996. This fact, my lord, will find at Lord's the synopsis of the.
No, why were you kept quiet for 5 years?
Lords, I was representing.
So you are getting, you are maintaining with some other money.
No.
Then without salary, how did you survive for 5 years?
Lords,
You are getting some extraneous material.
no, nothing.
Then how did you survive for 5 years?
Lords, my wife is also a teacher.
Huh?
My wife also earns. I was representing the authorities regularly.
You are not entitled to interest prior to filing of writ petition.
Lords, that is the discretion of my lords.
Yes, because there is a delay on your part.
Lords, I'm explaining the position. The writ petition has been disposed of by order dated 31/7/2018. Now about 5 years have passed. My full annual salary claim have not been
For
settled.
that you have to file contempt. Scope is limited in LPA.
Contempt application has been preferred, and the proceeding and this honorable this LPA bench has also directed the respondents to explain as to why the salary, what is the position about the payment of salary to the petitioner. To that effect, Lords, now they have constituted a committee. They have constituted a committee, and the committee has.
Have they preferred LPA against?
No, they did not. They did not. And my lord will find that at page number.
Yes, sir. What do you say, Mr.?
The salary has been paid to the appellant, Lord.
On what date?
15/2/2020. 2020.
2020.
Through the
Where is the material to show that it has been?
a supplementary counter affidavit at annexure.
Page number running page 99.
Annexure 8. Sorry, annexure 7, Lordship.
All right, for 2 years you paid interest from 2018 to 2020.
That during the pendency of this case, he has appointed on the ground of compensate ground.
Right, that is not.
A compensate appointment. He has been appointed on the compensate appointment.
No, sir. He was appointed the month of September 2012 or not?
He has been appointed in the year of 1906.
Sir, whatever it may be, salary has not been paid. You have not prepared LPA against the single judge order. That means you have accepted. You have paid the salary to him in 2020. Now, question is whether is he entitled to interest and from what date?
And that ground
What is your ground that he is not entitled to interest?
I only paid a salary to the appellant.
That two part salary, my entitlement goes to 30 lakhs. My entitlement is for 30 lakhs. To that effect, I have submitted
We
the.
are not concerned with that. We are concerned with only interest. Yes, take down.
No. Salary is also involved in this case.
Huh?
Salary is also the part of my writ petition pursuant to
Repetition is already disposed.
disposed of,
Huh.
and the order.
Which portion of the order the single judge you have agreed?
Just a minute, Lords. Order dated 28/1/2020 in this memo of appeal may kindly be seen. 20.
How is it relevant? How is it relevant? Question is you are entitled to interest or not? That's all.
Question is in relation to, as per the order dated 28/1/2020, whether I have been paid my full salary or not.
That cannot be examined.
For that, my lord may say rightly that for that contempt petition will see to it, lords. And in relation to the vacation of quarter, I was
That is not the
duly.
issue.
That is the issue. My lords, for that purpose, my lord may have a pain to go through relief number 14, my lords. 1, 3 and 1, 4 in the writ petition. The learned single.
Is there any interim order?
Yes, my lords.
In the writ petition?
Yes, my lords.
What is the date of interim order?
Just a minute, lords. I have annexed the same, lords.
First, file review. You have not addressed the argument on this issue.
I have addressed, my lords. And the
recording by the learned single judge.
learned single, the order passed by the learned single judge.
Dated 31/7/2018.
My lord.
In which paragraph he has dealt with the quarters matter?
I had requested his lordships, and there is interim protection by the learned single judge.
Here is the single judge order.
Single judge did not consider.
Therefore, go and file review.
Single judge did not consider my relief.
Go and file review, Mr. These two are issue, interest and quarters.
Well,
Yes, take them.
and one more thing for my lord's kind consideration, that this quarter was duly allotted to me.
Sir, we are not, we are reminding that we are asking you to approach the judge and seek review insofar as consideration of your prayer number 1-3. You say that you have argued, the judge has not considered. We don't know what has transpired between you and the single judge.
And one more thing is there, that there was specifically.
Sir, whatever it may be, go and file review, sir.
Right.
Recent LPA, appellate day, order of the learned single judge 31/7/2018, passed in CWC 5/2017, to the extent that the non-consideration of prayer number 1 within bracket 2I and 3I. Good stuff. They learn single in the petition, CWJC petitioner has sought for the following relief. The learned single judge considered the prayer number 1 and directed concerned authority to make payment of salary to the petitioner within a period of 4 months from the date of receipt / production of the copy of the order. However, the single judge has not considered prayer number 2 and 3. So far as the non-consideration of prayer number 2 is concerned, one can draw inference that the single judge has restricted only for payment of salary. Learned counsel for the appellant submitted that he has addressed the argument insofar as prayer number 3 also. So it's the provision of the order dated 31/7/2018 of alert single judge. There is not even iota of reference insofar as addressing the argument on prayer number 2, Roman 3. Therefore, the same cannot be adjudicated in LPA in the absence of any order of the learned single judge. Accordingly, appellant is permitted to file review insofar as the prayer number Roman 3 is concerned. The appellant has not been paid salary from time to time from the month of September 2012 till 15/2/2020. That is after disposal of the learned single judge, after orders of the learned single judge dated 31/7/2018, passed in CWJC 88/35/2017. Further, we notice that the respondents have not preferred LPA against the order of the learned single judge dated 31/7/2018. Therefore, insofar as the payment of salary to the appellant is concerned, it has attained finality. Now the question for consideration is whether appellant is entitled to interest on belated settlement of salary for the period from September 2012 to 15/2/2020, the date on which arrears of salary has been paid to the appellant. It should be noted that cause of action approved to the petitioner for the purpose of seeking salary was in the month of September 2012.
It arose in 2016 because from 12 to 16 nobody was paid. From 12 to 16 none in the office was paid.
Sir, we are going by prayer.
Madam.
Don't disturb by giving.
Since that is a fact, therefore I have submitted it.
But it is not there.
I have mentioned in the writ petition, Lords,
We can't revisit your writ petition.
in the month of September 2016.
Don't disturb by giving.
All right. I'm sorry.
Is to be noted that cause of action accrued to the petitioner for the purpose of seeking the judge in that
The month of September 2012. On the other hand, he slept over the matter for about 5 years while filing CWJC 8835/2017 in the year 2017. In other words, for about 5 years, the appellant has not taken any action to approach or invoke remedy before this court. Therefore, the appellant is not entitled to interest on arrears of salary during the period from September 2012 till 28/6/2017, the date on which CWGC was registered. However, he is entitled to interest at the rate of 8% per annum for the salary from the month of July 2017 till 15/2/2020. since there is a delay on the part of the concerned respondent in not releasing not disbursing the salary from time to time. The appellant is entitled to interest on belated settlement of arrears of salary in the light of habeas court decision in the case of Vijay Mehrotra versus Union of India 2001 9 ACC, page number 617. The concerned respondent is hereby directed to calculate interest and disburse the same within a period of 3 months from the date of receipt of this order, failing which the appellant is entitled to litigation cost of LPA litigation cost at the rate of rupees 25,000.
Lords, my two questions will be taken note of. In paragraph number 11 of the writ petition, I have specifically
Go and file review.
Lords, that will affect my career here also.
Huh?
Until 2016, I will be reading. Salary of the petitioner has been withheld from September 2020 along with the other. In the month of November 2016, salary of all other employees of Villa Parishad Katiyar have been paid to, but the petitioner has been denied. Until 16, the payment of all the employees of Villa Parishad was not being made, inclusive of mine.
Sorry, sir.
In November 16, others paid. Thereafter,
Sorry, sir.
one thing. Next thing, Lords, that only 4 lakhs.
Ask more. What has been?
I'm trying to have explanation in the order. Only 4 lakhs has been paid in the year 2020. My surviving grievances of 30 lakhs are also there, Lords.
For that, you have to make a representation. We are bound by only single judge order.
Single judge, as per the single judge order, 4 lakhs plus 30 lakhs.
Sir, have you challenged 15 to 2020? Arrears of salary paid to you?
Yes. In this affidavit,
How can you challenge here?
in this affidavit itself, I have made a specific submission that calculation.
You can't improve the LPA.
Not in the report, which has been the main basis.
At this stage, counsel for the appellant submitted that he is disputing the quantum of arrears of salary paid on 15 to 2020. This thing cannot be adjudicated in LPA proceedings. He has a fresh cause of action. Moreover, it is to be noted that the single judge has only directed for payment of arrears of salary, and the single judge has not determined what is the quantum of arrears of salary so as to apprise the aforementioned contention of the appellant. Accordingly, it is hereby rejected.
That is the instead of the exception, Lords. If liberty is granted to pursuant to my Lord's order, if I am granted liberty to uphold the authority.
Sir, last portion you get it deleted now itself. Otherwise, it will affect your.
No, that I have understood.
But what you want me to delete or not?
Let it be deleted, Lord.